Good morning, world. This is Rob Ryder. Today, notice of intention to file a claim in the Court of Claims. Because filing notice, or for filing notice prior to filing a lawsuit. And this is my attempt at complying with the jot and tittle of the law. And it appears that in some, if not all, states, it's mandatory you notice the state prior to filing a tort claim. So we'll go through that process a little bit and some other things that have been going on since my last video. Unfortunately, I had a virus in my video for quite some time. I just now got rid of it, I hope. But it kept me from using my microphone, so I couldn't do a video. I tried to upload this earlier last week, and come to find out, when I put it on, there was no audio. So I hope I remember the points I was pointing out then, and it's good to go through your notes more than once, so I'll just consider it a learning lesson and move on. But what is a tort? Well, it's an injury, a wrong, hence the expression executor dis un tort, of his own wrong. So first of all, it's an injury or wrong. Well, it could be a crime then. It could be criminal. So how can we use this to our advantage? As always, what we're trying to do is figure out how to use it to our advantage to get out of this crazy-ass system that we're in. So torts may be committed with force as trespasses, which may be an injury to a person, such as an assault, battery, imprisonment. Hey, they put you in handcuffs, you've been imprisoned. Pay attention. To the property in possession, or they may be committed without force. Torts of this nature are to the absolute, that would be unalienable, or relative rights of persons, or to personal property in possession or reversion, or to real property, corporeal or incorporeal, in possession or reversion. These injuries are either by nonfeasance, malfeasance, misfeasance. So at least some of these are only things that the state could do to you. And that would be somebody that deprives you of your rights because, anybody can commit a crime against you, but only certain people can deprive you of your rights. And that would be the government. You got the right, and they take it away. Well, that was deprivation of rights under color of law in violation 18 U.S.C. 242. File a claim. But before you can file a claim, possibly we have to file a notice. I'll tell you what I got to do here in just a second. Okay, let's try this again. So, nonfeasance, malfeasance, misfeasance. What are those? Well, nonfeasance is a failure to act. Malfeasance is the commission, as by a public official, of a wrongful or unlawful act involving or affecting the performance of one's duties. Well, that would be a crime. That's criminal. Misfeasance, a term used in tort law to describe an act that is legal but performed improperly. So, we'll get into that in just a minute. Hey, Rob Ryder, my email address is courtofrecord@aol.com. That's COURTOFRECORD@AOL.com. Phone number is 616-712-6179. If you could, please donate. I got a new PayPal account. Part of this video is about the things I've been doing with the business that I registered with the state treasury for my all cap letter name, saying, hey, that's my business. And I got a business license for it now and so forth. And so, one of the things I've done is I've opened up a PayPal account under that name, Robert Allen Ritluski. And the email address associated with it is Rob Ryder, ROBBRYDER @AOL.com. If you could use PayPal, one of those two would take you to the account. I used to use my daughter's PayPal account, AshleyRitluski@gmail.com. So if you did it that way before, well, I believe it was just done with using the email address. Or you could use the mail, Robert Allen Ritluski, 10955 14 Mile Road Northeast, Rockford, Michigan, 49341. And today is Saturday, the 23rd of September, 2017. Look up today because there's signs in the heavens. Today's the day for the Lady of Revelation 12 to appear in the sky. First time in 7,000 years. Won't happen again for another 7,000 years. I don't even know if they know it'll happen again. They just know it hasn't happened in this 7,000 years in either direction. It's the first time today that this particular alignment has been seen in the sky. And then on October 13th, which isn't that far away, hey, we have the 100-year anniversary of the miracle of the sun at Fatima, Portugal. So there are signs in the skies. Amen. Hey, one thing that happened in this time between my last video and now is I got an email that said, I am forever in your debt. Today, the prosecutor had my case dismissed. Let me read that again. Today, the prosecutor had my case dismissed. Did that say what it sounded like? Did it say, today, the prosecutor had my case dismissed? Well, that's what she told me. According to the judge, I was arrested for not showing up for an arraignment, which is not true. I get my $200 bond refunded and will be contacting an attorney to sue U of M, that would be University of Michigan, PD, that would be Police Department, for false imprisonment. Hey, didn't we just read about that as a tort? And injury. We read about that too. I didn't need any documents. Thanks again. Just wanted to say thanks and give you an update. And so this was Yvonne, and what we did in Yvonne's case, we'll look at the paperwork, is, we filed some papers into her court case. And when she got to court, they said, hey, the prosecutor dismissed your case. And they gave her back her bond money. A lot of what we're going to be talking about is the Court of Claims in Michigan, and they have an act for the Court of Claims. And in that act is a particular section that says notice of intention to file a claim, contents, time, verification, copies. So no claim may be maintained against the state unless the claimant, within 1 year after such claim has occurred, files in the office of the clerk of the Court of Claims either a written claim or a notice of intention to file a claim against the state or any of its departments, commissions, boards, institutions, arms, or agencies, stating the time and the place where such claim arose, and in detail the nature of the same, and of the items of damage alleged or claimed to have been sustained, which claim or notice shall be signed and verified by the claimant before an officer authorized to administer oaths. Such claim or notice shall designate any department, commission, board, institution, blah, 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 and a copy of such claim or notice shall be furnished to the clerk at the time of filing of the original for transmittal to the Attorney General and to each of the departments, commissions, boards, institutions, arms, or agencies designated. In all actions for property damage or personal injuries, claimant shall file with the clerk of the Court of Claims a notice of intention to file a claim, or the claim itself, within 6 months following the happening of the event giving rise to the cause of action. So when you read that, if you can just separate the fact that, well, the claim isn't necessarily the lawsuit, it's telling the state you have a claim, and that they've decided, well, we want you to tell not the Secretary of State or the Attorney General or the Governor. No, we want you to send it to this clerk of this Court of Claims that we've established and file it with the clerk. That's how you would start your claim. Not with a court case, with a notice, or with the claim. Because if you send them a claim, well, hey, you just noticed and you're putting a claim in. But I did it. I called it a notice of claim. We'll just, we'll see what I did exactly. And I know they have it now. I just don't know that what they're going to do yet. So that's simple enough. And so when, and this kind of all happened because Yvonne said, well, now I'm going to, she wants to find an attorney and sue the U of M for false imprisonment. And it's like, the U of M, that's really part of the state, right? It's a state college. So you're really filing a claim against the state of Michigan. So why not just cut to the chase, make your claim against the state of Michigan, or whatever state it is, because it's really the fiduciary, right? If anybody's a fiduciary, it's the state. And everybody else is their agent. And, and so that whatever happened to you is the evidence that you have a claim. But the claim's against the state, because it's the sovereign, it's the fiduciary. Well, let's not say it's sovereign. I get some people upset. But it's the fiduciary. And it has a duty. So let's see if we can make it do its thing. Okay, so what we did in her case, Yvonne's case, first of all, this was a notice to appear for her case. Right? See how they got her name backwards? Foster, Yvonne, Arlise. Well, that isn't your full legal name. You don't have to answer to that. See how the prosecutor used the middle initial? Well, he didn't use his full legal name either. Hey, I thought this was a legal matter. Everybody uses their legal name in legal matters. And she didn't pick this one. They picked it for her, and they picked this one to use. Brian L. Mackey. Well, there is no Brian L. Mackey. There's a Brian with a middle name, Mackey. That I would agree with. But there's no Brian L. Mackey who's been authorized to practice in the state of Michigan using anything other than his full legal name. And they had the plaintiff as the state of Michigan. I don't believe that's proper. The sovereign state of Michigan is called the state of Michigan. It was established in 1835. Constitution, I believe, was the very first one. And in the preamble, it says the style shall be the state of Michigan. And it's never been changed. So what we did was we took the information from this then, right? Because this had the court information and who was who in the zoo. And we put it on a thing called a motion, affidavit, and bench warrant form that you can get from the State Court Administrator's Office. Approved, SCAO, SCAO. All right, so we just started taking the information off. Okay, I guess it's the people of the state of Michigan are bringing the claim against some defendant. Right? That's a Jane Doe. That isn't Yvonne. But they're going to try to get her to agree to be that defendant. Right? Coerce her into it. I request that a bench warrant be issued and that Brian L. Mackey, P25745, 200 North Main Street, Suite 300, Ann Arbor, Michigan, check the box, held in contempt of court for the following reasons. Using false identity, prosecuting alleged crime in an improper venue by unauthorized process, depriving rights in violation of 18 U.S.C. 242. Now, I'd have said more on that, but that's all the room they gave, and so we put on the bottom, see attached affidavit of facts or something like that, whatever the words are. We'll see in just a second. This affidavit is made in my personal knowledge. Is sworn as a witness. I can testify competent to the facts of this affidavit. Signature, subscribed or sworn before me on County of Michigan, before notary. Okay, so we filled that out. And then Yvonne Arlise Foster, right, sui juris, in her full legal name, added this. Notice, take mandatory judicial notice of the law. Application for bench warrant. With all the information. Peaceful inhabitant, state of Michigan, truly believe the individual using the false identity, Brian L. Mackey, alleged prosecuted official for the plaintiff, for a plaintiff that has no legal standing in the state of Michigan, right? State of Michigan is not the state of Michigan. Unless they're trying to be the trustee. Get it? So, hey, now they got a duty. And using an unauthorized practice that violates MCL 750-217C, which has to do with using unauthorized practice, pleadings or proceedings, in other words, color of law, and a proceeding whose defendant, Foster Yvonne Arlise, is a legal fiction Jane Doe, that would be Yvonne Arlise Foster, am being coerced to accept as my identification. conducted in an improper venue, depriving myself of rights in violation 18 U.S.C. 242, that would be deprivation of rights under color of law, a federal crime that must be enforced in any courtroom, flying a gold fringe flag. That is not an amnesty flag, people. That is a United States Army flag. It's the one that the color guard guards. Just watch them. Go look at a color guard and see what flag the Army guy's carrying. It will be a gold fringed United States flag. It won't be the Navy. Deprivation of rights under color of law, a federal. I think I just said that, including Michigan's 15th Judicial District Court. So here's the point. Any courtroom you walk into has a gold fringe flag. Just cut to the chase, right? That's determining the jurisdiction because it's the venue. You're in a military venue. So tell the judge, Judge, you got a gold fringe flag in your courtroom. That makes this a military tribunal. It says so in Army Regulation AR 840-10, Section 2. Section 2, actually 2-3. And in there, it'll tell you all the places that a gold fringe flag can fly. And it'll also tell you that that unauthorized flying of a flag is fucking unauthorized. And it'll also tell you in Section 2-7 where a civilian who wants to fly the symbol of the nation is supposed to go to find out what they can fly. Display. Right? So they can display, according to the law that it takes you to, the one that you see in the school that you saw your whole life as a child growing up in a public school. They had no gold fringe flags in a public school. But they do have gold fringe flags in pretty much every municipal building. They're in every church. They're all over the place. Well, that makes that a military installation of some kind. I'm not just saying Army. I looked at an Army regulation because that's what I'm familiar with. But it's called AR 840-10. And so now we're in a military tribunal. So either this is a wrong venue for me or we're under some kind of military law, which is what I believe, right? Because they declared martial law in 1863 and it's never been rescinded. The Lieber Code, Article 2, states that once martial law has been declared, the only way for it to be undeclared, for lack of a better term, is a special mention in a peace treaty or a special proclamation by the commander-in-chief. And in this case, because once they declared martial law, that made all the governors commanders-in-chief. And that's what happened to Lincoln. He gave the power to the governors. They didn't want to give it back. And so we've been under some kind of martial law. And now it could be martial. It's not even, under martial law. Now it's a military government of some kind. And so technically we should be being governed under Field Manual 27-10, FM 27-10. Yada, 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 yada. Point is, hey, you got a gold fringe flag, Judge. So either this is a military tribunal and you have a duty to enforce the federal law, and this man has violated my rights under 18 U.S.C. 242, which is a federal law, or that flag is a war trophy and you're an insurgent. So what is it, Judge? Are you an enemy of the state, or are you going to enforce the federal law? And then see what he has to say. I do not believe any attorney or counselor at law is identified on the official roll of attorneys kept by the Supreme Court clerk in the style and name Brian L. Mackey. No, I do not believe there is. This individual's use of false identification and that number, P25745, is insufficient evidence that he is authorized to practice law in Michigan. It is my belief that in legal matters, all involved must use their full legal name. The use of Brian L. Mackey violates 6 CFR 37.3, which is the Real ID Act, which apparently they're going to start enforcing. I saw something on the internet. I think it was just this last week that only half the states have complied with the Real ID law so far. Anyways, it says that your full legal name is your first name, middle name, last name. I point out right now, if you go to Social Security Administration, and so if you Google Social Security Administration legal name, they'll tell you it's only your first name and your last name, and they don't care that what's in your middle name block, right? So when your mom and dad filled out the form to get your Social Security number, they put your middle name in the middle name block. Well, they believe they don't have to count that as part of your legal name. They go on to say, though, well, if you have a given name and you don't consider yourself to have a middle name, then put your given name in the first name block. But that isn't what the form says, right? And so, that to me is misfeasance. Yeah, it could be lawful, but that isn't the way they're doing it. That kind of stuff. So, so from the beginning, they haven't considered your middle name part of your legal name, and they gave you a middle initial instead, and that's the name that's on your Social Security account as its owner. Not the name on the front of the card, the name on the stub, which is torn off the card. I have the stub, and I've shown it numerous times in different videos, and it says on there the owner's name is Robert A. with the middle initial A. Rutluski. Well, no, it isn't. It's me, right? That's not my full legal name. Right, so this is the, forget what they said you did, right? This is the things they're doing to you. Plaintiff, State of Michigan, has no legal standing to prosecute as the government. The style of process being used is contrary to Michigan compiled law 600-1414, style of process. The style of process for courts of record shall be in the name of the people of the state of Michigan. Right? That's who it has to be from. In the name of the people of the state of Michigan. Foster Yvonne Arlise, as found on the notice to appear, that brings me to court, is not my full legal name. It is not my identity. It is not me. It is not my identification. A state police uniform law citation allegedly issued by an agent of the University of Michigan Police as UM 35500 does not properly cite any state law violation and claims the offense has happened in the county of Washington. This instrument can only be issued by an individual. So the thing I'm talking about is the uniform law citation. Can only be issued by an individual certified as a peace officer by the Michigan Commission on Law Enforcement Standards, and I do not believe my accuser has been issued a certificate by the Commission. County of Washington is not a venue or political subdivision of the state of Michigan and shares none of its sovereign powers. I do not believe any act of the legislature, charter, articles of association, or articles of incorporation evidence its lawful existence. I am not a subject to this venue. Officers of the court are attempting to steal my identity and coerce me into being their bondservant under a fictitious name. They are doing so by simulating an illegal process in violation of state law, federal law, common law, law of God. They are using their office of trust for private gain. This affidavit is made on my personal knowledge and sworn as a witness. I can testify competently to the facts in this affidavit. Hey, I just copied and pasted this off of the form that we already saw. Okay, so Yvonne had gotten a notice to go to court. And before she went to court, she went and filed this into the court case, just like go file stuff in your court case to the clerk at the window. And when she got to court, the case had been dismissed. Right? I didn't say it. She did. Today, the prosecutor had my case dismissed. According to the judge, I was arrested for not showing up to the arraignment, which is not true. Although she didn't argue the point with the judge, the case is dismissed. You'll be quiet and listen. I get my $200 bond refunded, which they did. Well, that would mean, hey, I didn't do anything wrong, so that was a false imprisonment because they put her in handcuffs and took her to the frickin' station, then took her to another station, and all this for a $200 bond, and had her daughter chasing her from place to place trying to catch up with the bond money or something. It just, yeah, right, that shit's got to come to an end. Okay, so that's where that sits right now. And so I'm going to be working with I already had been working with Yvonne to write her claim to the Court of Claims, and then I lost my computer, or my ability to do a video or anything. And so I said, I got to get that fixed, because unfortunately I got to do a video, or fortunately, I shouldn't say that. I'm happy to do the videos, but yeah, I got to get a video done. So I'll get back with her and finish hers up. But in the meantime, I had already sent my own, so we have an example to look at, and I can explain why I did it that way, and the way I did it. Okay, so some other things that happened in this time was, in my last video, I had shown that in it was a bankruptcy court in Western District of Michigan. One of the things we had tried to do was very similar to what we just showed, right? But we tried to do it against a attorney in a bankruptcy case. And because I don't believe the United States of America is the proper venue, right? That's King George's jurisdiction. He says he's the king or prince or whatever you want to call him of a kingdom called United States of America in his in the Treaty of Peace from 1783. Paris Peace Treaty, Treaty of Peace, 1783, just after the Revolutionary War. As opposed to the United States of America, which is the name of the Confederacy, shall be the United States of America, according to Article 1 of the Articles of Confederation and Perpetual Union. And it's got 4 of them in it. You know, I just got somebody's initials. Those initials go to a judge, yada, yada, yada. So we filed, this is the AO91 form, Federal Criminal Complaint, and we filed it into her court case. And if you watched the video just previous to this is where I talked about who, what, when, where, and why at the time. And on here we said that the dude was in contempt of court, right? Power of the court. A court of the United States shall have power to punish by fine or imprisonment or both at discretion such contempt or its authority and none other. See how that said? A court of the United States shall have power. Let's see what they did. Obviously, we weren't in a court of the United States, because this may be a court of the United States District Court for the Western District of Michigan, but this isn't, because U.S. Bankruptcy Court, Western District of Michigan, is not a court of the United States. The Bankruptcy Court of the District Court is just a division of the District Court. It doesn't have its own name. It would be United States District Court for the Western District of Michigan Bankruptcy Division, you know, or something like that. But it's not U.S. Bankruptcy Court. It's part of the District Court. That doesn't really fit in yet, but I just point out, hey, look at this thing says, a court of the United States shall have. Because they didn't use it, I don't believe that that court is the District Court. But when, now we're not talking about the same lady. We're no longer talking about Yvonne. Now we're talking about Linda. So in Linda's case, we filled this thing out, and she took it down to her notary public, which put a stamp on it, which I say, hey, I didn't know they would do that, but apparently they can. And, you know, sworn to before me and signed in my presence. She didn't sign as the judge, but she signed up here, so I'm going to say that's, you know, all okay. Okay, so we filed this into the court case, and then which one do I want to go to? That ended up getting this answer back from the court to that. And this happened after I did the video, so I guess I haven't talked about this part yet. Okay. But part of the other parts that we did is she went, and this would be from here. right? If you go to the federal court for the district you're in, so United States District Court, see, this doesn't say for the Western District of Michigan, United States District Court, Western District of Michigan. Well, to practice, you have to fill out this paperwork. Attorney admission and registration. Upon receipt of the above, the application will be submitted to the chief judge or designee for review. If the application is granted, the attorney will be added to the list of attorneys admitted to practice in this district, not in the state, in the district. And the attorney will receive a certificate of admission. Okay, so hey, they got a roll of attorneys at each federal district court. So I told Linda, we'll go tell him to give you a copy of his authorization. Let me see, there's one more thing here. Upon receipt of the completed forms, the attorney admission clerk will contact you with further instructions. So apparently they have somebody called the attorney admissions clerk that this paperwork goes to. That sounds like somebody you could talk to. And they give a phone number for the clerk's office. And the first time Linda did this, they weren't very helpful. But the second time they were. And so they will do it. And I guess all I can tell you is if you call there and tell them you want one and they say you can't have it or whatever, tell them then you want to complain to the chief judge, please put you into his office. Or into the chief clerk, because you're just talking to a counter troll that doesn't really know that you can, because sure you can. Right? It's a fucking public record. Right? The dude's been added to a roll of attorneys to practice in the court. You want to see that he's authorized to practice. So she asked for it, and they sent her a copy. And so this is where, hey, it gets a little more interesting. Because this says United States District Court, Western District of Michigan, like the website said. But not like the AO91 says. Let's read what it said. The clerk's office is in receipt of your request dated August 10th, 2017 regarding the admission status of attorney Dean Edward Rittberg. See, no middle initial E. Please let this letter serve as confirmation that attorney Dean Edward Rittberg was admitted to the United States District Court for the Western District of Michigan on May 27, 1986. Mr. Rittberg is active and in good standing and has no record of any disciplinary action in this court. In which court? In the court that uses for the as part of its name. This thing here, this is the proper name of a court, which is not the same name as this court here. There's no for the in it. And obviously they use it because, well, there it is, right? So it's part of the name of the court. And so this court isn't the court where they use full legal names, right? It's not that court. It's not that court, which is the same from the website. It's this court. So that's the court I want to put my paperwork into because I'm trying to get into the venue where the dude has to use his full legal name. So you need to use the court that has the word for the in it. And this had a seal on it, which says, it starts with seal of the U.S. District Court for the Western District of Mich. And of course, it's all in uppercase, but you can see seal of the U.S. District Court. And then here it says for the Western District of Mich. So this has for the in it. This has for the in it. This doesn't have for the in it. And it's called the United States District Court. But Linda's in a thing called the United States Bankruptcy Court. So now that we got all that kind of in our head, let's see what they said to her thing. Oh, before we do, we'll go one more. So we got that. That was from the federal court. But you can also go and get from your state court, from the roll of attorneys, well, the same thing, basically. So the Supreme Court of the state of Michigan. Hey, this may be who we're going to put a claim against. In my case, I, Larry S. Royster, clerk of the Michigan Supreme Court and custodian of the roll of attorneys, admitted to practice of law in this state, do hereby certify that as appears from the records, Dean Edward Rittberg was admitted to practice law in the courts of the state of Michigan on May 27th, 1986. Right? No middle initial. So the prosecutor that we saw in the first case from Yvonne, right, was using a middle initial. Yet, the state of Michigan says no, they use full legal names. Here's an example. Under the state of Michigan seal. Okay, so there's no doubt that, that's how the guy's registered to practice. Dean Edward Rittberg. No middle initial. So we get this answer back from United States Bankruptcy Court. Again, now looking at it, so I don't believe there is any bankruptcy court. This can't be a court of the United States because the law that we looked at, right, said a court of the United States shall have power to punish. And they didn't. This matter comes before the court upon criminal complaints, docket 45, filed by Linda Allen Bay, debtor, line. I don't want to read this whole thing. In the complaint, the defendant appears to seek criminal sanctions against Mr. Rittberg, counsel for the plaintiff, for pursuing this adversary proceeding on behalf of the plaintiff. Well, that's only partly true. That isn't what she wrote. The defendant alleges that Mr. Rittberg's use of his middle initial in the signature block in pleadings indicates that he is using a false identification. That's correct. The complaint is purportedly brought by the United States of America against Mr. Rittberg. That's incorrect. I mean, you can see we crossed it out and put the United States of America with the T capitalized, and they didn't do it. But utilized as the case caption for this adversary proceeding to which neither the United States nor Mr. Rittberg are a party. Okay, so the United States nor Mr. Rittberg are a party to the proceeding. Okay, however, he is their attorney, so he's still using the middle initial name in a freaking court case, and, well, that isn't the name he can practice under. For reasons set forth below, the court shall deny the complaint. This court is a court of limited jurisdiction over bankruptcy cases and matters related thereto. It does not have jurisdiction over criminal matters. But of course, our matter was it was criminal contempt of court. We put it on a criminal complaint, but it was contempt of court. Right? Isn't that a criminal matter? Put you in jail for it. Okay. Relief requested is denied pursuant to blah, blah, blah. So they denied it. And so, out of this, it was like, okay, well, the federal court has a court of claims. We could go there and do what we're doing in the state. But maybe in this case, what we need to do is go back and do this again, but to send it to the United States District Court for the Western District of Michigan. To that clerk. Right? To the clerk, United States District Court for the Western District of Michigan. And hope that they get it to the right person. That they do the right thing. So, that's a couple of the things that have happened, since my last video. And, well, I got one more thing here. And then Bobby in Arizona, we had put some things into his case. Actually, one of the first things we started doing here a year or so ago, or even a little bit longer now, is, we get a court case and we would write to the chief judge and say, hey, what's happening in your court it's a crime. Pointing out A, B, and C. And over time, those have gotten to be more defined. And, now it's just a few sentences of stuff. The attorney isn't using his proper name. They're not using your proper name. They're not using the proper name of the court. So it means you're in an improper venue. They didn't bring you to a state court that has any jurisdiction in the law that they're trying to enforce. They just pretend they do. And so that we had done that in here to the presiding judge of the Superior Court of Arizona. Now, Bob didn't have a court case, but he had been apparently arrested, taken to jail, had his car impounded, fingerprint taken, released, no bond, and no citation issued. Yet they kept his car for 30 days in an impound. And so there's really no court case yet to go against, say, hey, this has happened in this court case. So we were just saying, hey, this is a crime. And here's the facts, right? We were trying to get an arrest warrant issued by providing an affidavit of facts. Well, we did that. So I make writing to acknowledge receipt of your letter, petition for show cause hearing for contempt, deprivation under color of law, contempt of the will of the people. I don't think she used quite the caption that we used. The canons of judicial conduct prevent judges and court staff from giving legal advice, so we're not going to tell you what to do. And close, please find information to assist you in accessing the Superior Court's self-service center designed to help yourself in court. You may also consult an attorney to advise you what action should be best for your individual situation. I am returning your documents so that you may follow the proper procedure in the proper venue. So she alludes to me, well, hey, there is a thing that is the proper venue. We're not there. She wasn't the proper venue. Now, here, she's Maricopa County Superior Court, right? Presiding judge, Maricopa County Superior Court. Well, how come here, Superior Court of Arizona, County of Maricopa? County of Maricopa, Maricopa County, I say they're not the same thing. I say everything has one legal name, and that's the one you need to use. If you're not using that one, well, it's not a legal matter. And so, not that anything came out of this other than to say that much right there. Follow proper procedure in the proper venue. And that would be, hey, for Bob, I'm thinking now we got to go find the same thing. We got to go find the court in Arizona that you would file a notice that the agency of the state is depriving you of your rights, and make the state of Arizona, which is the fiduciary, the defendant. Or, at this point, the one you're claiming against. We're not in a court case yet. Okay, I'm going to pause for a second. I got to switch some things around, so hang on. Okay. So, I'm just thinking about this. If you've never watched one of my videos before, and you've been say, hey, you need to go watch this video for whatever reason, pretty much everything I'm talking about has been over the last 5 or 6 videos. And so if you're on Rob Ryder on YouTube, ROBBBRYDER, on YouTube, and you were to sort the videos by upload date, and then look for the one that says Samuel G. was tried in a venue beyond the sea, and started there and watched all the ones newer than that, it covers most of these ideas, right? So, because one of the things I had done here recently is, well, some people want to run from the name. I'm claiming the damn name. Claim the name. And we tried it before, doing it as a DBA. But really, it's not a DBA. You're doing business in your name. It may be uppercase compared to lowercase, but, I don't know that that's a style difference as much as... because they say it makes, to the government, it makes no difference if it's upper or lower. Is what they say. But Robert Allen compared to Robert A., well, that's a different style of name. Even if they're both my names, they're different styles. Or Ritluski, Robert Allen is a different style than Robert Allen Ritluski. Right? That's a style difference. And those things, you need to do it as a DBA. And so I said, okay, I'm going to go and say that my all cap letter name is my business. And I'm going to be doing, business in my name. And why would I do that? Well, because anytime you go and buy something at the store and you pay sales tax, you just participated in commerce. Right? You're a contractor in a retail purchase. And what you're trading these little green pieces of paper with for whatever it is they're giving you. But it isn't money, it's legal tender. Right? So there's a medium, it's just a medium of exchange. And but hey, if that's what they want them things with $1 with the numbers on it. They're going to give you the groceries. Well, I shouldn't use groceries. We don't pay sales tax on groceries here. But you get the point. You just participated in commerce, and sales tax is the only tax that the sovereign state charges you for. Right? Like your property taxes and shit like that. Those are all local taxes. They're not from the state. So if you're going to participate in commerce and you need to have a license, well, then get a license and be recognized as the taxpayer of the state instead of the one that's running from paying the taxes. Because you're already paying them. We're talking about sales tax. It's already been collected. Right? You're the taxpayer, not the collector. And as it turns out, you got to fill out a form every year, put it in could be quarterly and even annual forms. But all the forms have to do with how much tax did you collect. I'm just going to put all zeros. Right? I'm not collecting. I'm the taxpayer. Point is, hey, they gave me a license. They sent it to me. And so what it said is Treasury uses your FEIN number as your sales tax account number whenever possible. If you do not have an FEIN, Treasury has assigned you a 9-character account number beginning with TR, which means Treasury Registered, and followed by a 7-digit number. You should notify the Michigan Department of Treasury to change your business ownership, business address, yada, yada, yada. You can access your MTO account or using Michigan Treasury Online. You can access your existing Michigan Treasury Online account, or you will need to register your business to begin using Treasury's electronic services. And so this is really all it is, right? State of Michigan, Department of Treasury, Robert Allen Retluski, my address, sales tax license with my account number. So now I'm thinking if I was to go to, and I haven't done this part yet, but to go to, if I really had to have an FEIN, I would use this instead of my Social Security number. Because we're talking about my business. Not about me, that person needing an FEIN. But you notice how it came in uppercase and uppercase. It's like, well, one of these should be proper case. But I don't even know that it needs to be. Now, right? It's okay, if you want to say that that's not a style difference, then fine. Then I'm the owner of my own business. But what they did online is they have the owner of this business with a guy with a middle initial. So I did this back in, when did this come to me? Got a date on it? Date. This one did. Notice date, August 4, 2017. Right? We received your registration for Michigan taxes. However, information is missing or incomplete. You provided this information by visiting Michigan Treasury Online. Business ownership type was left blank or invalid. And I had to think about that. I said, well, how, when I filled the form out, I was sure that I said it was a sole proprietorship. So I didn't leave it blank. So are they saying that's invalid? Well, now how can that be? It's me doing business in my name. How can you tell me it's invalid? Or left blank? But still had given me a license. Right? So they gave me a license. And they said that the type was invalid. And if I wanted to change it, I had to go online and do some stuff. So I went to register online. And this is the site, and I did. And there's Robert Allen Rutluski, right? That's the business we're talking about. But on the system, it shows a guy with a middle initial being the owner. Well, that isn't my full legal name. This is supposed to be a legal matter. How can somebody with a middle initial be the owner of my property? It's not my legal name. And as you can see here, I had to, so what I had to end up doing was actually for me, I had to register as Robert Rutluski, because on the very first page, when you went on to register, there was 3 lines or 3 blanks to fill out. First name, middle initial, last name. And I said, well, I'm not going to fill out middle initial. I'm not doing that. All right? What I'm going to do is I'll do what Social Security said, and I'll put my given name on the first name block. Well, I tried to do that. It wouldn't let me do that either. So I said, okay, well, fine. Just put Robert Rutluski, go in and get it done, and I'm going to go bitch about it. Right? But when I got online, I didn't use an A to register. And for this business, as an owner, it shows a guy with a middle initial. And not only that, it had these notices waiting for me that said, hey, I hadn't filled some paperwork out for some prior years. It's like, well, I just did this. I just put it online. How can you tell me I didn't file for 2015 and 2016? Which is what it was saying to me. And then I thought about it. I said, oh, you know why? Because this thing has always been here. Yeah, it didn't get put now when I did it. No, it's always been there, and I've accessed it. And so Robert A. Rutluski isn't filling out the frickin' paperwork, even though he's registered the business. And then that would mean, well, if he's not filling out the paperwork at some point and filing returns, that they're going to consider the property to be abandoned. And it would go into the abandoned property of the Treasury. Okay. I think that's what they're doing. And so my thought was, well, I'm going to complain now to the Court of Claims that the state, the fiduciary, state of Michigan, the fiduciary is allowing someone to use a pseudonym or at least an unregistered fictitious name as the owner of my business, because that's not my name. And so if they can't show me that this name has been registered someplace as a fictitious name to be used for business, then it's an unauthorized registered name. And the state has violated their fiduciary duty to protect my property, if that's what their intention was. And instead, they're concealing my property from me. So, is that the one I want to go to? All right, so this is my state sales tax license. And, this wasn't in the videos to do with venue, but it was soon after when I was going through this, and I showed the form. It's just a 2-page form. But I'm talking about the form that if you wanted to start a business in your state, you're supposed to register it for taxes with whoever the tax collector is for the state. Here is the Department of Treasury. Not for local taxes, not the county, the state. Right? Where would you register your sole proprietorship with the state? Not the Secretary of State. This is for taxes. Right? Where would you register? You go there and you register your business, and you tell them you need a sales tax license or a use tax license. In Arizona, they call it a retail license. And so that's shown in the videos too, that Bob had already done this. Now, a lady from Wisconsin had just gotten hers done. And then we've gone to the next step and said, well, we're going to take that and we're going to go claim these DBAs, legal fictions, that have been made from her name. And those would be on your deed of trust, on your warranty deed or grant deed, mortgage, and the most important one to me is on the Schedule A of your title insurance. if you look at the grantee on this warranty deed, if you look at the borrower on the deed of trust or mortgage, and you look at the entitled to on the title insurance, none of those are using your proper name. They're not using your full legal name. They created a legal fiction. Right? And they gave it to them. They didn't give it to you. They put it in the name of a legal fiction. So when you go to court saying, hey, that's mine, well, there's no evidence it's yours. It's not in your name. It's in the name of this legal fiction. And so what we did is we went and said, well, let's go claim those instead. And that's what she's doing now. In fact, she just did it on Friday, I think it was. And they're going to send her the paperwork. Right? So she had already done the state one, claimed her name, went back, said, now I'm claiming these DBAs. We're going to get those DBA forms from the state, and now we're going to take them and put them into her court case and say, hey, that's my property. I'm the owner. And then complain against the title insurance company because the title insurance company entitled your property in fee, right? The fee title you're looking for has been given to a legal fiction, not to you. And the legal fiction is on the Schedule A. It's going to tell you who it's entitled to. So go claim that name. After you've claimed your proper name, and get a hold of the insurance company and say, hey, you didn't entitle the property to the right person. Fix it, or I'm taking your ass to court. And actually, you'd be taking the state of Michigan to court because they just have these people doing it for them. They're trustees of the state. All right. Okay, next. And I put this on here just because the other thing I did, now that I had claimed my business, and I had my driver's license number, right? So here's my old driver's license number. Operator's license, as they call it, R342-745-051-691, expired 2009. I hadn't had one since, and I went here a couple years ago to see about getting one, or to get an ID or something, because my children were going to have some grandbabies. I need to get a little more legalized. And when I went there, they said, well, I'm no longer in the system. I didn't show them that I had this. Right? I said, this is my name, Robert Allen Berlusky. Yeah, I used to live here. I don't know what happened to my paperwork. Who really knows? I just need new ID. Well, you're not in the system. You're going to have to start over. So you would think I would get a new number, is my point. Well, I went and did it this time all the way to the end. And when I got it back, I got this Michigan identification number, which is the same as this number here. And this is the number they put on the line on a ticket that says driver's license number. Well, I thought I wasn't in the system, but yet there I am. And so I got an ID that has the same number on it. That's the only thing that's on this thing. Right? But it's on the original, or now that I've gotten this, I've actually got it back now, but it's on the this is the temporary I filled out at the Secretary of State's office, or DMV, whatever you have in your state, to get my license, to get my ID. And one reason I wanted to do that was in the state personal identification card, which the little thing is I'm showing you goes with this thing right here, Michigan Temporary Personal Identification Card. State Personal Identification Card. Hey, that's what we're talking about. An official state personal identification card must contain the following. I want an official state personal identification card. And you get all the way to the end, so that's what I got. And you get down here, it says a valid official state personal identification card presented by the individual to whom the card is issued is considered the same as a valid state of Michigan driver's license when identification is required, except as otherwise specifically provided by law. This is your driver's license. A valid official state personal identification card presented by the individual to whom the card is issued is considered the same as a valid state Michigan driver's license. That means your valid official state personal identification card is a valid state of Michigan driver's license. when identification is requested, except as otherwise specifically provided in law, which means it needs to be written in the law that you can't use a valid state official personal identification card. And I ain't found any place where it's written that way, because that isn't how it's going to work. This thing here is your valid. Which one are you? This one here, when you get my personal state identification card, right, it is my valid driver's license. And so it's not an operator's license, right? That's what they have you going for. You think you're going to get this. You don't want this. You want to get a personal identification card. I'm just going by what the law says, right? I don't argue with the law. I'm trying to comply with it. I'm not trying to make up my own. I'm going to do what it says. And the law said that this I can use for identification unless it specifically says I can't. So there you are. Here's my identification. All right. But the reason for this was to talk about the Court of Claims. Because the state of Michigan is acting as the trustee, then I want to put a claim against the state of Michigan. And in Michigan, they have a court set up called the Michigan Court of Claims. But before that, this has only been the last 3-4 years. It had been that it was through the Ingham County, which is the county court where the state capital is. They had the Court of Claims. So look in the county where your state capital is and see if that's the court where you file a claim against your state, if you don't have a separate Court of Claims. This case in the Court of Appeals, though, I'm just showing because it says what the State of Michigan Court of Appeals says is the jurisdiction of the Court of Claims. Because this actually happened in a circuit court where somebody filed a case under 42 United States Code 1983. Deprivation of rights under color of law. Plaintiff brought this action under 42 U.S.C. 1983, naming 3 employees. Plaintiff asserted that the individuals violated his constitutional rights by refusing to remove a homosexual predator label from the plaintiff's file. The circuit court granted summary disposition, finding exclusive jurisdiction was in the Court of Claims. Right? So the circuit court, apparently this court, said it's exclusive jurisdiction of the Court of Claims, that the Court of Claims has exclusive jurisdiction over Title 42 actions. The Court of Claims has exclusive jurisdiction to hear claims against the state in any of its instrumentalities for money damages. All these different cases will tell you so. This jurisdiction, what jurisdiction? Exclusive jurisdiction. Also extends to suits against state officers where the officer was acting in his official capacity when committing the complained of acts. Right? So now we're not just talking money damages. Now we're talking about things state officers do in their official capacity. And the Court of Claims has jurisdiction over actions under 42 U.S.C. 1983 and the state and federal constitutions. Well, that means it has jurisdiction over laws of the United States. It's Title 42, that's just one of the United States Code. If it's got that one, it's got them all. And the lowercase state and federal constitutions, I'm going to say that's the same one because lowercase state to me means that's the federal territory before it became an incorporated state. Like the federal territory of Michigan in 1835 became the state of Michigan in 1836. So if you're going to make it a constitutional issue, they have it also. So where do you take your claim? You take it to the Court of Claims. Exclusive jurisdiction over plaintiff's claims, the rest of the Court of Claims, period. So that's all there is to it. You got to take it to the frickin' Court of Claims. And what was this here? Now here's one from the Court of Appeals about the Court of Claims, for a case from the Court of Claims. And this is getting into why I did what I'm going to show you next, why I did it the way I did, because of this case right here. So this is State of Michigan Court of Appeals, L'Oreal Stone, Department of Michigan State Police. I'm trying to think of an easy way you could find this online. You wanted to look yourself. But I don't worry about it. Plaintiff appeals by right. Defendant's motion for summary disposition under government immunity. So basically, the Court of Claims agreed with the defendant that they had immunity. And that's what people complain about, the trying to file a claim against the state. They always say, well, they have government immunity. Okay, so let's see what happens. So this happened in 2007. Plaintiff filed a verified complaint in 2010. Right, that's the complaint. The complaint also averred that the plaintiff filed a notice of intention to file a claim, the notice, in 2007. Defendant filed its answer, affirmative defenses, on July 30th, 2010. Okay, so in 2007, something happened, and this person filed a notice of intention to file a claim in 2007. For whatever reason, a verified complaint wasn't submitted until 2010. Right, and there, that's where we're starting at. And, because this is just a summary from the Court of Appeals, it's not like you have all the filings that were put into the court case to see what happened. I hope I don't need to go look at those, but that may be something for the future. Defendant filed a motion for summary disposition in 2012. Then the arguments were heard in December 2012. Defendant argued plaintiff's notice of intention to file a claim was defective for failure to comply with notice provisions of the Court of Claims. Defendant asserted the phrase verified before an officer authorized to administer oaths meant the required use of a jurat to show verification before an officer authorized to administer oaths. Okay, so first right off the bat, hey, forget the claim. This is all about the notice. We're just talking about the notice was defective. All right, the notice was defective. Why was it defective? Defendant asserted the phrase verified by an officer authorized to administer oaths meant the required use of a jurat to show a verification officer authorized to administer oaths, saying that the person didn't do that. And I want to show something here also, right? That Department of Michigan State Police is the defendant. But where's the state of Michigan, right? This is an agency of the state. The state of Michigan is the frickin' fiduciary. So, I'm going to put state of Michigan. Department of Michigan State Police. But the state of Michigan is the one I have my claim against. Okay, so the plaintiff countered by urging focus on the meaning of the term verified before an officer authorized to administer oaths, and argued verification did not require use of notary jurat, but should be understood in terms of some Michigan Court Rule 2.114 in the absence of statutory definition. Plaintiff asserted that if the legislature had intended to require notary seal or affidavit, it would have used those words, but it did not. Further, the plaintiff's counsel was a notary. The plaintiff's counsel was a notary. The plaintiff's counsel was a notary. Hey, then attorneys are also notary publics. And the document was signed in front of him, thus satisfying the requirement that the notice was signed in front of an officer authorized to administer oaths. Defendant responded to, so this is state police, did not apply to cure defect of notice because notice was not dated as 2114 required and was otherwise and there was otherwise a statute, MCL 664-31, which was clear as to the notice requirements. Defendant contended that even if the plaintiff's attorney was a notary, there's no evidence from the four corners of the notice that it was signed and verified before an officer authorized to administer oaths. Okay, the Court of Claims agreed with defendant that an attorney was not a person authorized to administer oaths. The plaintiff's attorney status as a notary was not evident for the four corners of the notice. Four corners. Hey, that sounds like it's almost like common law. Like we're doing this more like in common law than statutory law. And all these things are just adjudicated facts in a common law case. But this all is hanging on one thing so far. We're just talking about the notice. That's what the whole thing is about, was the notice done properly. And one person says, the defendant says, well, it wasn't done properly. It doesn't have a notary jurat on it. And the plaintiff is saying, well, it was done before a notary because the attorney's a notary, and that's who she signed it before. But there's no place on the paperwork that it shows that it was done in front of a notary. So let's continue on. So, but MCL was a statute otherwise provided that the notice needed to be verified, and it does. Lastly, the court acknowledged that it found plaintiff's notice was not verified in compliance with 6431 for the reasons specifically stated in the defendant's reply brief. And that's what I'd like to see is, well, what was the reply brief of the defendant? The defendant's reply brief additionally argued the meaning of verified before an officer authorized to administer oath should require the notice to be in the form of a notarized affidavit. The court therefore adopted the defendant's argument, and the plaintiff's notice should have contained notary jurat in order to fulfill the requirements, and that it be verified before an officer authorized to administer oaths. So the circuit court said, you're right, it needs to have a notarized affidavit. Right? That's what it came down to. That would be the proper thing to do, to verify before an officer authorized to administer oaths. That has to be notarized affidavit. Okay, well then it went to the appeals court. So now what's the appeals court have to say? Notice of intention to file a claim in the court of claims. This court's analysis must begin with the cases of, here's some cases. In these cases, plaintiff was involved in an automobile collision with a government-owned vehicle and filed notices to appraise the government of their intent to file a suit and seek damages for personal injury and property damage. In both Rowland and McCann, the issue was the timeliness of the plaintiff's filing of the verified notice of intent to file a claim with the clerk of the court of claims. And one of them went to the Supreme Court, and they reiterated that such statutory notice requirements must be interpreted and enforced as plainly written, that no judicially created saving construction is permitted to avoid the clear statutory mandate. So the court can't make a savings clause to save the government from being sued, because this all has to do with, well, can you sue the government or not, right? So do they have immunity? That would be the savings clause. And they don't. Okay, but this case didn't involve anything to do with timeliness. Generally, in Michigan, government agencies cannot be sued for tort liability absent a statutory exception. Here, plaintiff complaint alleged defendant was liable under motor vehicle exception, something or other, which provides that government agencies shall be liable for bodily injury and property damage resulting from negligent operation of any agent, employee, blah, blah, blah. As part of her suit, plaintiff also required to follow the notice and filing provision of the Court of Claims in order to validate her claim, right? So as part of her suit, plaintiff was also required to follow the notice and filing provisions of the Court of Claims Act in order to validate her claim. Specifically, MCL 664-31 requires plaintiff to file a notice of intention to file a claim with the clerk of the Court of Claims. Now, that's what the Court of Appeals is saying. It requires the plaintiff to file a notice of intention to file a claim with the clerk of the Court of Claims. So why would you do anything other than that first? Was my thinking. I'll do that first. Although that isn't exactly what the law says. But as I'm seeing this now, right, first of all, I didn't notice that far up. The Court of Claims said no. for its reasons, and it agreed that there had to be verified under an affidavit. But now it's in the Court of Appeals, and the Court of Appeals is saying that according to the Supreme Court, you can't add statutory things, or you can't add to the statute. It needs to be as plainly written, and nowhere in the thing does it say it needs to have a notary jurat. It just says what you have to do, which is this part right here. No claim may be maintained against the state unless the claimant, within 1 year after such claim has occurred, files in the office of the clerk of the court of claims either a written claim or a written notice of intent to file a claim against the state or any of its departments, commissions, boards, institutions, arms, or agencies, stating the time and place where the claim arose, detail the nature of the claim, and items of damage alleged or claimed to have been sustained. Which claim or notice shall be signed and verified by the claimant before an officer authorized to administer oaths. It doesn't say, and do it as an affidavit or use a notary or jurat, or, right? None of that shit's in there, so you can't add that. But this says you can file a claim or a written notice of claim. And here, this is the opinion of the appeals court. It says specifically, what we're reading says, requires the plaintiff to file a notice of intention to file a claim with the clerk of the court of claims. Well, that isn't what it says. It says you can file a claim or. So my point is, there'd be one more thing to complain about. The fact that, well, that isn't what it said, in case the Court of Appeals didn't find in your favor. It says you could file a claim or a written notice of intention to file a claim. But the appeals court saying, no, you have to file a notice of intention to file a claim. So I just decided, well, I'm going to go ahead and do that. Right? I'm going to do what the appeals court said, because the appeals court in Michigan is the court that supplies the judges to sit on the court of claims. In case I hadn't mentioned that yet. They take 4 of the appeals court judges who have statewide jurisdiction. You know, all the other judges below them, they just have countywide jurisdiction. These are the judges that have statewide jurisdiction. I guess that makes them the state court. And give it to them. And they're the ones that are then chosen to sit on the court of claims to hear claims against the state of Michigan. So if you take it to the local county court, well, that isn't the court that has jurisdiction over the state. It only has jurisdiction in the county. Now, I'm not saying that all court systems are set up the same. That's how mine is set up. Right? Where do you take a claim in your state to put a claim in against the state and make them the frickin', make them the defendant, respondent. Okay, such claim or notice of claim shall designate any department. We know that. And a copy of such claim or notice shall be furnished to the clerk at time of filing of the original for transmittal to the Attorney General. Okay, so you got to file it with the clerk. They're going to send a copy to the Attorney General, transmit the original to the Attorney General, and file another copy with themselves. Bada boom, bada bing. In all actions for property damage or personal injuries, claimant shall file with the clerk of the court of claims a notice of intention to file a claim, or the claim itself within 6 months following what happened. Again, it says the notice or the claim. Okay. So, this is how the appeals court read what happened, right? Their interpretation of the adjudicative facts that brought this to the appeals court from the court of claims in the first place. Plaintiff, that's the lady trying to get the remedy, submitted for this court's review a copy of her notice of intent to file a claim and a certified letter from the Ingham County Court of Claims. The notice designated the Michigan State Police as the department plaintiff filed her claim against. Right? Michigan State Police as the department plaintiff filed her case against. It also stated that time is 2007, place, intersection, right? Gave time, place, and so forth. The notice further alleges damages plaintiff sought to recover by her claim The notice ended with the declaration, I declare the statement above to be true to the best of my information, knowledge, and belief, which was followed by the signatures of the plaintiff, the salutation respectively submitted, and the signature of her employee or her attorney. Right? So the attorney did sign it under her signature, respectively submitted and signed the paperwork. And remember, her attorney is also a notary public. So she is in front of an officer that could administer an oath when she signed it. The notice had a section titled dated, but there was no date next to it. So, because they say you got to put dated on there, is one of the things, but there was no date next to it. Now, I don't know why that is, but do you need to put the word dated on it? Just, is that a jot and tittle? So I put it on and put the date next to it, but nevertheless, in their case, because she did this before an attorney, so the attorney's helping her fill this paperwork out, they just had the word dated, but no date next to it. The front page of the notice also contained a filed date stamp. Hey, could that be what they're talking about? The filed date stamp. Is that what dated means? Not dated, put the date you did it. Dated the date that it was filed with a date stamp from the Ingham County Court of Claims on November 15, 2017. That dated. So I have to play with the words. I think that's really what they mean. It's the file stamp is the dated. Right? That shows it went in. It was put into the system of the clerk of the Court of Claims. It acknowledged the accompanying certified letter from the Ingham County Court of Claims, and now it's just the Michigan Court of Claims because they passed this act, was dated November 20th, 2017. It acknowledged receipt of the plaintiff's notice of intention to file a claim in the Court of Claims, confirmed that the notice was filed on the 15th of November 2017, assigned a notice number, and indicated that copies were forwarded to an Assistant Attorney General of the Michigan State Police. Given the contents of the notice, both parties agreed that all conditions had been satisfied, save one. Now, I have a little bit of a problem with this because it's an Assistant Attorney General and the Michigan State Police. Because it said to send it to the Attorney General. It didn't say to send it to an assistant. All right, here's the law. Original for transmittal to the Attorney General and to each of the departments. But because she didn't make so I'm just wondering, is this because she didn't make the state of Michigan the defendant? She only made the Michigan State Police the defendant. But they're saying everything was done except save one, right? So everybody agreed that whatever needed to be done had been done in this section, except for one thing. And that one thing is, well, did she do the signature on her notice properly? Our interpretation of any statutory language always begins with the objective of discerning the legislation's intent. The task begins by examining the language of the statute itself. The words of the statute provide the most reliable evidence of its intent. The words of a statute provide a most reliable evidence of intent. Sun Valley Foods, yada, yada, yada. The issue before this court is whether plaintiff complied with the provisions that her notice be verified by the claimant before an officer authorized to administer oaths, right? This whole fucking case is hanging, finally, on one adjudicative fact. Is the issue before the court is whether plaintiff complied with the provisions that her notice be verified by the claimant before an officer authorized to administer oaths. Because the statute provided no definition of the word verified nor the phrase of an officer authorized to administer oaths for guidance, both parties looked elsewhere to their definitions and examples that support their position. Plaintiff's counsel urged the trial court to adopt the definition of verification contained in MCR 2114B and to accept the plaintiff's verified information before him and that his status as an attorney and notary made him an officer authorized to administer oaths. The authorization requirement. Plaintiff's counsel argues that his status as attorney notary made an officer authorized to administer oaths. We disagree. The trial court was correct in concluding that the plaintiff's attorney was not an officer authorized to administer oaths. Other than the instance where a particular officer is required, right? So other than where it's required, a particular officer, MCL 601-440 only lists a justice, a judge, a clerk of the court, or a notary public as persons who may administer oaths. An attorney is not amongst those listed, right? You don't see the word attorney there. Attorney can't do it. Plaintiff also cites no statute specifically granting authority to attorneys who are not notary publics to administer oaths. Accepting as true that the plaintiff's attorney was also a notary public, the plaintiff's attorney failed to comply with Michigan Notary Public Act, MCL 55-261, at SEQ, when a notary public performs a notarial act, he is required to print, type, stamp, or otherwise imprint mechanically or electronically a notary jurat. Right? So a notary must use a notary jurat. While no specific form is required, a jurat must convey all the following information. The name of the notary public as it appears in his or her application for commission as notary public. So whatever they did there, even if they use a middle initial name, that's the name they got to use. They didn't use a middle name, that's the name they got to use. However they did it on the application is the way they need to sign the damn form. The statement, Notary Public, State of Michigan, County of. The statement, my commission expires in performing a notarial act in a county other than the county of commission. The statement, acting in the county of. The date the notarial act was performed. Hey, I wonder if that means dated. Right? That the notary needs to date it. The fact that none of this information appeared on plaintiff's notice is evidence the plaintiff's attorney was not acting in his notarial capacity. Right? He didn't do that. He just wrote, respectfully submitted and signed it. Well, then he didn't do it as a notary. And so, really, these aren't notaries, these aren't attorneys who are also notary publics. These are notary republics, state officers that are also attorneys. That's how we should look at them. I believe every notary or every attorney is a notary public. And that's the state office. Right? So they are a state officer. And even though they're not doing it as a notary republic, they are one. And because they did it improperly, well, that's, he's trying to do it as a notary. If he's saying that was a notarial act, he violated the fucking act as a notary. The defendant, on the other hand, right, so he could have been made a frickin' party to the party. Defendant, on the other hand, this would be the state of Michigan State Police, argues the proper authorization of a notice by an officer authorized to administer oaths requires a notary jurat be displayed on the face of the notice. Right? They're saying, well, you got to do it that way. But the state disagrees, or the Court of Appeals. We find the trial court erred in concluding the plaintiff's notice required a notary jurat in order to fulfill the condition of verification under MCL 600-6431. A jurat is a certification added to an affidavit or deposition stating when and before what no authority the affidavit or deposition was made. A notice is neither an affidavit nor a deposition. The statute also neither states that a jurat is required nor that an affidavit must accompany the notice. In accordance with the holdings of Rowland and McCannon, this court will not add further requirements to the notice provisions of MCL 600-6431. A statute only requires verification on the part of the claimant, and the claimant performs the act of verification before an officer authorized to administer oaths. Plaintiff argues definition of verification contained in should be used to interpret the meaning of verification someplace else. We disagree. Okay, so before we go there, so what do we have in this case then? Right, well, this would say that a notice is neither an affidavit nor deposition. Okay. A jurat is a certification added to an affidavit or deposition stating that it was done, stating when and before what authority the affidavit or deposition was done. A notice is neither an affidavit or deposition. So it doesn't have to have a notary jurat on there, because there are officers, right, the justices, judges, clerks of the court, that aren't doing it as a notary, yet they're pointed out in the law that they can administer an oath. So you could go to those people and sign it before them. But if you don't go to those people and you go to a notary, well, they need to put a notary jurat on it, because that's what notaries do. Otherwise, it wasn't done before a notary. Even though you did it before an attorney that is a notary, the fact that the attorney didn't do it as a notarial act means it wasn't done before a notary. He wasn't wearing his notary hat when he did it. Yet he did it and said he is, and so therefore, in reality, it's a violation of the Notary Act by her attorney. He owes her a remedy. Plaintiff argues definition of verification. Okay, the trial court correctly determined MCR 2114 is not applicable. Clearly states the rule applies to all pleadings, motions, affidavits, and other papers provided for by these rules. Notice of intention to file a claim is a document exclusive to the procedural requirements of the Court of Claims Act and not provided for in Michigan court rules. Well, that was a good enough reason for me, since it said the notice of intention to file a claim is a document exclusive to the procedural requirements of the Court of Claims Act. I want to comply with the Court of Claims Act. I'm going to file a notice of intention to file a claim. The Court of Claims only enables Michigan court rules to apply in instances of pleadings and therefore does not apply to notices. Right? They didn't say the word notice. It doesn't apply. Further, MCR 2114, section on verification states that except when otherwise specifically provided, rule or statute, a document need not be verified or accompanied by an affidavit. Not only do we have a statute here that specifically mandates that the document must be verified, we have instructions how it must be verified. Right? So that it has to be and how to do it are stated in MCL 6431. MCR 2114 gives choice of verification by oath or declaration and does not require an officer authorized to administer oaths to be involved. Verification is a certification of truth. It is also defined a formal declaration made in presence of an authorized officer, such as a notary public, whereby one swears to the truth of a statement in the document. Okay, verification is a certification of truth. Okay, here plaintiff's signature would suffice when under the declaration I declare and the statement above are true to the best of my information, knowledge, and belief, if verification alone and nothing more were required. However, MCL 600-6431 does require more. Effective verification under MCL 600-6431 is plaintiff certifying the truth of the document and doing so under oath. The statute implies that the claimant must take an oath because a requirement of her verification occurred before an officer authorized to administer oaths. Oaths is an external pledge or asseveration. Okay, but what they said was here, verification is certification of truth. It is also defined as a formal declaration in the presence of an authorized officer, such as a notary public. Right? a formal declaration whereby one swears to the truth of statements of documents. Here, plaintiff's signature would suffice when under the declaration, I declare the statement above are true to the best of my information, knowledge, and belief if verification alone and nothing more were required. So there was nothing wrong with the words that she used. That's a perfectly good statement. They just didn't do the last part. Do it before somebody who can administer oaths. Plaintiff's attorney submitted his own affidavit to the court and argues that the affidavit cures defect. Okay, so the plaintiff's attorney then submitted his own affidavit to the court and argued that the affidavit cures the defect for failing to have the jurat or its equivalent on the face of the notice. We note the plaintiff's affidavit was executed some 5 years after the incident which gave rise to the plaintiff's claim. So here, even 5 years later, the plaintiff is executing a piece of paper, well outside of the 1 year that it was supposed to have been done. So if it hadn't been done correctly to begin with, doing it now isn't going to make it correct because you're past the time. Defendant does not contest that the attorney was, in fact, a notary at the time the plaintiff signed the notice. The defendant also does not contest the plaintiff averred that the facts in the affidavit are true. The affidavit indicates the plaintiff's attorney inquired as to the truthfulness of the matters of the notice. The statute does not prescribe the kind of inquiry that must be made, nor does any language in the statutory requirement evidence of oath or affirmation beyond the face of the notice. Most importantly, an error here was procedural, not substantive. They held another case that it has essentially always been a rule in Michigan, that defendants must apprise the plaintiff of the nature of the defense relied upon so that he might prepare to meet and avoid surprise at the trial. Today, pursuant to MCR, something or other, defendant waives any affirmative defenses not set forth in the defense's first responsive pleading. Right? So if you don't point out your affirmative defenses at the beginning, then you've missed your opportunity to do it. An affirmative defense presumes liability and accepts the plaintiff's prima facie case, but asserts that the defendant is not liable for other reasons not set forth in the plaintiff's pleadings. We hold the plaintiff to failure to comply with purely procedural prerequisites from commencing a medical malpractice action is therefore an affirmative defense that must be raised pursuant to MCR 2111. All that to say what? That because the plaintiff or the defendant didn't bring up this stuff he's talking about now, he can't bring it up later. But for us, it means if you're the defendant in a case and you don't make your affirmative defenses at the beginning, right? An affirmative defense presumes liability and accepts a plaintiff's prima facie case. Well, I really don't want that to be the case. I don't agree that there is a case. So I don't want to give them an affirmative defense. Waives any affirmative defenses not set forth in defendant's first responsive pleading. So if you're going to make any defense in your first responsive pleading, you just agreed that there is a case against you, but for the reasons you're saying, it's not going to stick. And the court can say, well, the reason that you said doesn't matter because you didn't do it right. So that means that the plaintiff has a case. You've just agreed to it, and we're going to fine for the plaintiff. That's how she rolls. Okay, that was a lot of stuff, but at the end of the day, it comes down to, well, you got to do the paperwork right. It's the jots and tittles of the law. Right? What's a notarial act? Because that was one of the things. So it means any of the act of notary public commissioned in this state is authorized to perform, including but not limited to the taking of an acknowledgement, the administration of an oath or affirmation, the taking of verification upon oath or affirmation, which is really what we're trying to do. So you need to tell a notary, I guess, hey, I want to do taking of a verification upon oath or affirmation. What does your book say? Right? What's the proper certificate to put on the paper to show that that's why I'm here? Taking of a verification upon oath or affirmation. And the witnessing or attesting of a signature performed in compliance with this act. So you're doing two things. Right? Verification upon oath or affirmation and witnessing the signature. And that's what the notary's doing for you. All right. So, remembering how this started, right? I got a sales tax license that says I'm the owner of this business. But the state of Michigan has it in a guy on the middle initial's name as the owner of my business in my full legal name. That I did the original registration not even using the middle name because it wouldn't let me. It said I had to use the middle initial, and I wasn't going to do it. And that's what this whole point is about, right? They're allowing people to use these unregistered fictitious names to represent you. And they're the fucking fiduciary. The state of Michigan is. Your state. That's what I wanted to hit. Okay, so notice of intention to file a claim in the Court of Claims. The United States of America, ex-rel. Robert Allen Retluski, relator and claimant, right? I'm relating for the United States of America, which represents the sovereign power as its relator and the claimant, right? That its laws have been violated. Versus State of Michigan, Department of Treasury. They're the respondent. Dated 18 September, year of our Lord 2017. What is it? I'm asking for qui tam prosecution under 42 U.S.C. 1983. Civil action for deprivation of rights under color of law for respondents' apparent malfeasance and violation of Constitution, federal and state law, such as 18 U.S.C. 242, 18 U.S.C. 1622, MCL 750, 217C. Claimant was me, in care of my business. This legal notice is to inform the state of Michigan of the claimant's intention of filing a claim in the Court of Claims for deprivation of rights under color of law, identification theft, the unlawful conversion of my private property to the unjust use of others, possible subordination of perjury, and malfeasance. I'm sure I could have thought of more, but I was trying to get it on one piece of paper. In July 2017, I, Robert Allen Retluski, the real party in interest of Social Security account 374506794, executed a Michigan Department of Treasury registration for Michigan taxes Form 518 in the capacity of owner of a business having the name Robert Allen Retluski and legal address 10955 14 Mile Road Northeast, Michigan 49341-8664 to register this business for state tax purposes. Got it? Right? I told them who I was, not who I'm not, and what's mine. I claimed the Social Security account, that I registered it, I claimed the business, they're mine, in my full legal name. On or about the 28th of July 2017, a sales tax license was issued by the state of Michigan for this business under account number TR2530258. Correspondence that accompanied this this sales tax license states that changes to the account should be executed using Michigan Treasury Online. Michigan Treasury Online requires an initial registration. This online registration only allows the registrant to register using first name, middle initial, last name, Robert A. Retluski. There is no provision for one's full legal name, Robert Allen Retluski. This system even denied use of Robert Allen as my first name. I do not believe a doing business as DBA in Michigan I should say has been registered for assumed name, Robert A. Rutluski, and I do not authorize its use as my identification. Robert Allen Rutluski is my full legal name. R342-745-051-691 is my official state identification card number. And 374-506-794 is my Social Security account number. This authenticated identification represents the owner of business, Robert Allen Rutluski, TR 253-0258. Those are all mine. Mine. State of Michigan registration policy led to its malfeasance by forcing one to register using a style of name other than their full legal name in a legal matter involving private property rights. I am forced by the state of Michigan to be identified by an alias with inferior status instead of identification by my full legal name, sui juris. Take judicial notice. Homeland Security has defined full legal name as an individual's first name, middle names, and last name or surname without use of initials or nicknames. See 6 CFR 37.3. My true identification is compromised by the state of Michigan's intentional tort, concealing my full legal name, clouding my rights, titles, and interests, and assets, requiring an audit and full accounting of my property. I probably should have put a semicolon there. Upon completing the initial registration under duress and examining my business information on Michigan Treasury Online, I soon realized the state of Michigan Department of Treasury previously authorized the registration of my business entity, Robert Allen Rutluski, and its legal address by an individual using the pseudonym Robert A. Rutluski. The online account notices from the state of Michigan Department of Treasury claim that the business, Robert Allen Rutluski, TR 253-0258, has not yet filed its 2015 or 2016 returns. It is my belief the resulting defects caused by these deceitful acts of malfeasance by officers of the state are used against me, damaging my good name and diminishing my civil status, causing encumbrances to be placed against my property to deny myself access to my estate and create the appearance of my abandonment of my property. I believe many years previous to 2015 are claimed delinquent by the state, and these assets are unjustly assumed abandoned. The state of Michigan compels the use of false identifications in legal matters that require the use of full legal names, violating the state of Michigan's fiduciary duty. The result is an unlawful conversion of my property and theft of my true identification. Officers of the state of Michigan are derelict in their duties, appear to be using their public office for private gain, and are implicated in possible subordination of perjury by allowing unregistered legal fictions to be used in place of a full legal name in legal matters. The state of Michigan is violating its own penal law, MCL 75217C. Google that sometime. Legal process, impersonation, false representation are actions as public officers or employee definitions. I demand the state of Michigan decree and certify in my full legal name, Robert Allen Rutluski, I am the real party and interest in the business entity, Robert Allen Rutluski, with sales tax license, TR 253-0258, and exclusive owner of its assets, including those incorporated by reference. I ask the state register myself in the appropriate local assessment roll, assess my personal property, liquidate the same, give a complete accounting, settle and discharge all debts, pay all lawful taxes, release the balance to myself for my use and enjoyment, and all other relief and equitable remedies the court deems just. I declare the statements above are true, but to the best of my information, knowledge, and belief. Robert Allen Rutluski, subscribed and sworn before me, and hey, that's dated September 18, 2017, by a judge, court clerk, magistrate, notary public. Ashley Holiday, right? State of Michigan, yeah, got that. County of Ionia, yeah, got that. My commission expires, yeah, got that. Acting in the county of, yeah, got that. And so then I sent it by certified mail. And this is interesting because this is what we came to believe by doing some research, right? That they have this thing up here where it says official use. And this is where you're supposed to put the name of the place you're sending it. So I'm sending it to the Court of Claims clerk's office. And I got that off the Court of Claims website, right? It says Court of Claims clerk's office. And when you take it down there, then they overstamp it and put in here Lansing, Michigan 48909. Now, because somebody took this, well, I guess they agree that's where the Court of Claims office is. Right? And then sent to Hall of Justice, street address, P.O. Box, Lansing, Michigan. Now, I don't know that that was the proper way to do it, but that's the way I did it because, you know, when you look at their addresses, that's kind of how they're set up. That all these places, if you remember on the one from Bobby in Arizona, I showed earlier, it said it was the old county courthouse, and then it had a street address. Mine says Hall of Justice, and it has a street address. But the place I'm sending it to there, right, the official use there is the Court of Claims clerk's office, which is at the Hall of Justice. Certified mail, I told them that I wanted it first class mail, certified, return receipt requested. And so you can see they sent this as first class package. Which now I'm looking at this, I'm a little bit upset because we were trying to send stuff first class package a month ago with Bob's stuff. They were giving us all sorts of shit. Because if you send it first class package, you could use this certified mail, the green one, but they have a brown one that's certified mail for merchandise. Right? And so, but you need to send it first class mail for sure because you're sending legal documents and they need to be sent first class mail. And I had read in a court case in Michigan that the Court of Appeals considered certified mail, right, to be, and they were taking this out of a dictionary, you know, some college dictionary from 2007, so just, you know, a dictionary, what certified mail was, and it's uninsured first class mail, return receipt requested. Uninsured first class mail, return receipt requested. Well, one of the things we found out is if you don't tell them you want to send first class mail, it isn't necessarily sent first class mail. So you have to tell them that. And certified, return receipt requested. Paid for all of them. What bothers me is, you know, none of that shit shows up over here. All right, no certified fee. They got 0, 0, 0, 0, 0. But I went from 316 to 926. So why is all that? Those questions to be answered by the post office. And then on the envelope, again, this was reading the different manuals that the post office has, right? And they had one about what you need to put on the face of an envelope, right? That you have to write on there first class mail below where the stamps would go. Right? It needs to be endorsed. Special. Here, look at this one again. Return receipt fee. Endorsement required. Now I'm thinking I was supposed to sign that. Right? Because there's nothing there. And that bothers me because I did pay for the return receipt. It's over here on this thing here. But why didn't they put it on the certified mail receipt? This is what you're supposed to use as your receipt to show that you mailed it. It's what's got the postage stamp or the postmark on it. Okay. And then we put so this was a hard cardboard. I got it from the UPS store, right? You couldn't bend it, and so it could be considered packaged because it can't be bent. They actually have a manual that tells you if it's called a flat or if it's called a package, and they call it first class package. So I know now I can use this other form, which is I got one right here. What do they call this thing? A 3804, return receipt for merchandise, which I might try next time if I have to do one. But right, so I tore the thing off the top and I put that on the bottom of the green card that's over here. You can't see it. It's below where you put the address. I put this address here, the same as the address I did here. Now what else did I do? Oh, and then this is going to get torn off here, and this is the part they give you back, this bottom part. So below here it says return receipt requested, because it talked about endorsing the envelope, return receipt requested, just like for first class mail. So I did both of those, but now I see on this thing also, well, I'd seen it before, it says return receipt requested, endorsement required, but there's nothing in there. It's like, oh, does that mean I was supposed to write something in there? Because they didn't do it. Blah, 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 blah. So this has been delivered now. Last thing to look at, we're just about done, right? It got delivered. I'm waiting for the green card to return. In the lady's case that we were reading, in her case, it got delivered on the 15th of the month to the Court of Claims, and on the 20th of the month, they mailed her a certified mail. So if I can get that back, that'll at least show me how they do it. Say, okay, well, that's the way that they did it. That's the way I should do it. Because they asked for things to be sent by certified mail. Don't have time to talk about it in this video, but one of the other things in this was for the Michigan Tax Tribunal, that for you to invoke the jurisdiction of the tax tribunal requires you to send them certified mail. It's the act of sending certified mail that invokes their jurisdiction in tax matters. So I really want to get back certified mail from the appeals court so I know what they consider to be certified mail. Okay, so that's where we're at today. And this is like the 5th time I did this video or started it. So hopefully it's finally gotten done. And because I've done it so many times, I don't remember if I talked about certain things in this video that I did in the ones that didn't get done. I just have to wait and see what comes out of it. But I believe I covered all the main topics that I wanted to cover. And so I'm going to leave it here for today. And just ask you that if you can, if you're still watching, and say, hey, that's interesting. Good job, Rob. Hey, can you please send me a donation? Right now I can't make my rent at the end of the month, and it's the 23rd. Although this could be the end of the world. Today is the 23rd. Signs are in the heavens. Maybe it's all done. It's all done today anyways, and the devil's world falls apart, and second coming of Jesus. Amen. Okay, everybody have a great day. Enjoy your weekend. See you.